Hello and good morning to the panelists and participants. Thank you for joining us today. The time now is 2:19, and we shall start our session on Capture the Positivity, Law Graduates Adapting to Effects of COVID-19. I'm Chloe, and it is my honor to be a moderator for this session. First of all, I would like to thank everyone for joining our first ever virtual ALSA Malaysia training workshop in collaboration with ALSA UITM, ALSA IIUM, and ALSA USIM. This year's EMW theme, COVID-19, the Law's Versatility and Adversity, is inspired by how the COVID-19 pandemic has cast many industries, including the legal profession, into uncharted territory. Before we start, I would like to remind all participants to always mute their microphones to avoid any disturbances, but I highly encourage you to leave your cameras on so that the panelists can see you. And I highly encourage participants to relay your concerns and any questions for the panelists in the chat box for the Q&A session at the end of the session. I would like to welcome our first panelist for this session, Ms. Idza Hajar. Ms. Idza is an experienced partner in the litigation practice group. She obtained her Bachelor of Laws degree from University Technology Mara and was admitted as an advocate and solicitor of the High Court of Malaya in 2007. Idza's main area of practice is litigation, and Ms. Idza has appeared in the lower courts, high courts, and appellate courts of Malaysia, and frequently renders opinions on various corporations and organizations, both locally and abroad in the areas of law below. Ms. Idza also actively participates in leadership programs for young lawyers and law students, and often appears as judge for various mooting competitions nationwide. Ms. Idza is a recommended lawyer in the Legal 500 2019 Asia Pacific for Dispute Resolution, and was named Feature Star by Benchmark Litigation Asia Pacific 2019 in 2020, and Outstanding Lawyer 2020 for Client Service and Client Service Excellence by Asia Law. Thank you for sparing your weekend to join us today, Ms. Idza. How are you feeling?
It's a pleasure for me to join, actually. I'm quite nervous, to be honest. I always get nervous when I speak to students. I don't know why. I'd rather be submitting my case in court, to be honest, but I'm going to try my best and hope everybody is ready to listen and to have a chat afterwards, I would think.
Thank you for joining us today. I'm sure the participants here are excited to hear what you have to say about the topic. Next, I would like to welcome our second panel, Mr. Ranjan Chandran. He graduated with a Bachelor of Law Honours from the University of London in 1994, and with a second-class upper honours degree, and completed the Certificate of Legal Practice in 1995. He was admitted to the High Court of Malaya in 1996 and has been in practice for 25 years now. Mr. Ranjan had his own practice under the name and style of Messrs. Ranjan Chitravati and Nick for 16 years now, from 1999 to 2015. In the year 2016, he joined the firm of Messrs. Hakim Arabi and Associates as a partner. He appears frequently as counsel in the appellate courts and the high courts. He has a passion for writing articles and has had many of his articles published in the Current Law Journal, Malaysian Law Review Appeals Law Journal, and numerous interviews with the Edge Weekly. He has spoken at many different webinars organized by the Bar Council, Current Law Journal, and on 2 occasions for ALSA, namely on the topic Force Majeure Emergence from MCO on 7th September 2020, and the topic of defamation and freedom of speech on 28th September 2020. I appreciate your presence here today to share your knowledge with us, Mr. Ranjan. I hope you're in good health and you're excited for today's event.
Indeed, by God's grace, I thank learned moderator, Ms. Chloe, and all the participants who are here today. Learned co-speaker upon Idza and myself will do everything we possibly can to make this a meaningful session for all of you, rest assured.
Thank you, I'm sure you're very excited. So COVID-19 pandemic has forced change in an old age profession nearly overnight. We look at how law firms are adjusting to new technologies now and how courts may adopt new technologies going forward. As courthouses around the country continue trials and hearings and even close completely, courts and attorneys alike have been forced to adopt new technologies at every single stage of proceedings. So now I will be sharing Ms. Idza's slides, and she'll be presenting her work first.
Thank you, Chloe.
Everybody see this?
Yes. All right, thank you, everybody. So I think I'll start with the more general portions of the topics that we're supposed to cover today together with me and Ranjan. We're talking about, when it comes to litigation, the things that might stay the same, the things that will be different. And if it's going to be different, how are you as students or future graduates, future lawyers, the future generation of, or the future phase of litigation is going to firstly adapt by when you enter the scene, and how do you think you will then adapt for the future? Because like I said, you are the future of litigation or the face of litigation. So maybe Chloe, you can go to the next slide. I mean, we talk about the future, we talk about current situation, but actually, when I really look at it, the future is what's happening right now. I would have to start off by saying that insofar as my view is concerned, when I look at the substance of litigation, now the substance of litigation, the goal of why people litigate, the heart and soul of the law generally, that remains the same. When you talk about substance, what is the goal of parties resorting to dispute resolution? The goal is to basically both parties come together. They can't sort out their disputes, and therefore they carry on seeking other third parties to resolve, come to a finding, put forward the best case for them, and get an independent third party to decide either, whichever way, and they agree to be bound by that finding. Insofar as that, the essence of why we litigate matters, or we parties refer disputes to third parties, that I don't see changing anytime soon. In fact, that's the way it has always been for hundreds of years, and it will continue to be the reason why people litigate for the next 200-300 years, I hope. I mean, that's what I figure. For as long as disputes arise in human existence, I think it will still go on and on and on. So when we talk about changes, what changes are we looking at? If you look at COVID-19 and how it has affected litigation, especially the manner and processes. So we firstly talk about process. So the process of litigating, of the manner in which we resolve disputes, those are where we see the changes happening. So when we talk about processes, so once the processes have changed, the manner in which litigators or legal practitioners present their case or their side of the story also changes, because the processes have changed. So I give you following general examples, which I think Ranjan will elaborate upon later in his portion of the talk. We talk about, firstly, maybe I'll give an example. Back in the day when I first started practice, and this was it was not as long as Ranjan. It doesn't go far back. I'm only in practice for 14 years this year. When I was starting out practice, there was no such thing as e-filing, right? So what you have to do, you have to prepare everything, certain amount of copies. You have to bring the full copies to court, and you have to go to the counter and you have to file it. And it was some years ago, I think, before the e-filing system was introduced. And e-filing is prior to COVID, so it's been in existence for a while. And what it does is it has replaced the need for having physical copies to be brought to court and to be brought to the counter for the purposes of filing. So now filing for all court papers, even your short court papers or long court papers, when you start chambering, when you're concluding your chambering, is all done online. You don't even have to go to court for the purposes of filing something anymore. So that's over time technology taking over something which was traditionally done physically. And I see that happening for almost every single aspect of litigation, of the processes surrounding litigation. For instance, previously, when we go to court before a trial, before a hearing, when a case starts after you file it, you have case managements. Back in the day, and for some matters now, you have to go physically to court, you have to meet the deputy registrars, you have to physically state out your case, introduce yourself, and the deputy registrar will manage the case, will give directions. But the core point here is that you would have to actually go to court. Now, substantially, case managements have been replaced by what we call e-review. There is no more physical case managements. Most of the time, 90% of the time, I would say, for most cases, civil cases especially, you would just have to log in into a system. So for every firm, you will be given a password. When you sign up, you will be given a password and a username. And all the lawyers in that firm for any of the cases will go into the e-review system using the username and password, and you will be allowed into what we call the e-review system. So there will be boxes and panels of where, you then introduce parties. So generally the traditional portion of introduction, like the plaintiff introduces the defendants and all that, that is still there. As a chambering student or lawyers or even me, when I go into e-review, I still do the same thing when it comes to what the traditional method was of introducing people. So the tradition of lawyers introducing each other still continues, but now it is done online in writing. So you type and say you introduce parties, the deputy registrar takes note, the deputy registrar or registrar asks you about the updates of the case, what has been filed, what has not been filed. They then give directions, but everything is done online. And you can't even hear their voices. Most of the time you can't see their faces. It is just typing away. So it's not even sort of like a webinar like this. It is basically just typing away in the system, and the case management can be done anywhere, so long as you have a phone with an internet connection. You can even do it in your car while you're doing other things, so long as that web page is open in your phone or the app is there. You can conduct case management or e-review. Going one step further after case management, we now, because of COVID, so previously e-review as well is prior to COVID-19. It was introduced some years before that. It was not spurred on by COVID-19. Something I think that is spurred on by COVID-19 specifically is remote hearings. So prior to this, we stopped short of allowing hearings or trials or appeals online. So there was e-filing, there was e-review to ease the process, but hearings, trials, and appeals were always conducted face-to-face. Come COVID-19, I think during the first tranche of the MCO, proceedings in court wasn't proceeding at all. So when the MCO was then extended further until, was it May or June for the second tranche, then the courts realized, look, there's a backlog of cases going on right now. So they then identified some cases which they were of the view could be conducted remotely. So I don't know if any of the students, any of you guys in this webinar tuned into the very ever first Court of Appeal hearing. It was actually streamed on YouTube in the Court of Appeal, the Kehakiman channel. So I was tuning in because to me it was historic. It was the first time in my life I've ever seen this happen. I think it was an appeal for a running down case. It was an accident case. So my learned friends who were submitting on the plaintiff and appellant and the respondent, and the judges, the quorum heard it and they gave a decision thereafter. So COVID-19 spurred on the concept of which was unheard of or not even unfathomable at the time, of trying to conduct hearings, trials, and appeals online. And there's pros and cons to this, but which Ranjan will speak of. But just to tell everybody in the webinar that concept of remote hearings, which is I think is here to stay, was spurred on by COVID-19. So what I think would only become the norm in 10 years down the line has now, started almost immediately because of COVID-19. So it was actually spurred on by this event. And lastly, that to me, another portion of litigation or practice that was also spurred on by COVID-19 is service of documents. So prior to this, most parties, when it comes to plaintiff or solicitors, when it comes to service of documents with each other, we don't usually resort by way of email, or we do by way of email as a formality or an additional step. We will always serve each other documents by hand. Either one way or the other. But because of COVID-19 and CMCO now and MCO earlier, you just couldn't serve documents and deadlines were running. So affidavits in reply became due, the pleadings became due, the rules of court and the timelines that were in place were still running despite this period. The courts didn't really issue out any directive at that time that time stops running for the period of MCO. So we're all under the impression that everything was, the timelines were still ongoing. Because of that, I think most parties, solicitors rather, opted to agree between themselves, hey, look, I'm going to accept service by way of email. Serve me the documents by email is fine. You've already e-filed it anyway. You don't need to serve me the hard copy until maybe after the MCO or CMCO. Because of the difficulties in movement, we couldn't move. So that in particular, I think was spurred on by COVID-19 as well. So when it comes to process and how litigation is presented, that has definitely gone through a drastic change, I would say, because of COVID-19. Chloe, you can go on to the next slide. Right, so when you talk about what other advances in it here, it is happening at rapid pace. I'll give you an example. I think Sabah and Sarawak courts are at the cutting edge of they've always been advanced, advanced rather. I was recently, before the CMCO, was in Labuan, and I was very surprised to see, they already have a system where there's no such thing as a recording. You just get up and the system records it automatically. And there's also, as you speak, there'll be a script that appears. So they capture what you say. And that's already in the Labuan, Sabah and Sarawak courts. So for instance, before COVID, before the MCO was first announced, the Sabah courts actually, in one of their criminal cases, employed AI to advise a particular sentencing that should be meted up. And this was in February, if I'm not mistaken. There was then, after that, a whole slew of a debate on this decision that was given, and which was advised by AI. So I'm not sure, I think all of you know what AI is. AI is artificial intelligence. It basically studies patterns and trends, and once it studies it, it comes out with a recommendation. So the magistrate in this particular case keyed in the facts of the case and keyed in the mitigating factors and aggravating factors that was submitted on by litigators, either for prosecutor, for the defense. And once that those things were keyed in, the AI system that was employed in the court came up with a recommendation for sentencing. So that is what has happened. So there was a lot of backlash on issues whether it was even constitutional. You rely on advice of a person who's not alive and a machine. There was a lot of debate on this issue, but the point is, it is happening. And this particular advancement actually happened prior to COVID. And I to the introduction, or rather COVID happening right now, the reliance on AI, I'm not entirely sure, on AI insofar as the courts are concerned, for certain offences or certain matters, I'm not saying all, I think for some matters, AI will be entirely unsuitable. But for some offences, I suppose maybe traffic offences or whatnot, it might be relied upon more and more and more by the courts in the future. So as the courts employ more and more AI, which is already starting to, at least in Sabah and Sarawak, we can see, some of the different trends. Some lawyers argue that, look, it is up to me to submit on what the mitigating factors are. And not all mitigating factors are the same. So mitigating factors will apply differently to a 18-year-old as opposed to a 40-year-old, because age and experience and each offender is an individual, and that must be taken into account of. So getting who is not a person, who is a machine, to decide on how to punish actual people is not suitable. But then again, it is something that I think in the future will remain to be seen. It's sort of like coming to the bridge and deciding what to do next when you reach that stage. But whether or not we like it, it is here to stay, and I think it's something that will only grow in the future. Chloe, can you go to the next slide? So when it comes to the future and when it comes to litigation, I think what we have to be aware of as students and as young lawyers as well, as COVID-19 steps and disrupts lives, it also disrupts industries and businesses. So there are some industries will I think will be phased out, will face immense difficulty in surviving. There is also some industries which will be going uphill, in an uphill trajectory. I'll give you some examples. The oil industry is facing difficulty because the demand for it has gone down. And this is pegged to a region of other industries, for instance, because the planes aren't flying. The aviation and maritime sectors are hindered by the fact that they can't move. So the demand for the oil that they use normally is less. Other industries like, the pharmaceutical industries, people who generate medication, do research, the glove industry, and Malaysia is the biggest producer of rubber gloves in the world, has gone an uphill trajectory. So some businesses face difficulties and some businesses arise, you can see different disputes coming up. So there's different disputes coming up because of different businesses. So a lot of questions were asked to me: what is the most valuable resource in the world at the moment? What has replaced oil and gas? So Chloe, can you go to the next slide? So contrary to, I get a lot of answers when it comes to my talk and whatever, but the most valuable resource in the world right now, and its weight is worth more than gold or oil, is actually data. So your information, everything you post online, your accounting details, your age, what you prefer, what kind of products you buy, that is what is most valuable at the moment. Because data and information is most valuable, Chloe, can you go to the next slide? You can see trends when it comes to litigation on what will be litigated. It might evolve. Some portions of litigation will remain the same, but other disputes will be on the rise. So disputes relating to privacy, for instance, and when it comes to privacy, dealing with companies, breaches of information, disputes relating to data and information, some disputes are already brewing, and I'm in the midst of them, and you can see how companies struggle to protect the data that they own from breaches and all that. And another branch of it that I see on the rise, because I'm involved in it, is disputes relating to corporate insolvency. So as companies struggle to survive, like aviation industry, the movie industry, all these industries, the retail industry struggle, they will try to either save the company by resorting to mechanisms in the Companies Act. Corporate insolvency disputes will be on the rise. Judicial management, winding up, creditors voluntary winding up, all those disputes. So it's a different type of disputes that will be on the rise. Chloe, next slide. So when it comes to us, or rather you as students or new graduates, what should you consider? As all these industries struggle, what are your financial expectations vis-a-vis the reality of businesses and how much they can pay you as you exit your student life into working life? And you also have to ask yourself this question: conducting litigation related work from home, is this even possible? I think we can resolve this or chat about this in the question and answer session. And your work security, because as industries change, is there work for you as litigators coming into the workforce? So these are some of the issues that can arise that we can maybe chat about later. Chloe, next slide. Right, so some of the things that you can do to prepare yourself when you go into the workforce: you must be prepared to do new and unfamiliar things. I give an example. Corporate insolvency, for instance, is a new area in Malaysia. We copied and pasted the provisions in the Companies Act from Singapore and the UK, and there's little or no litigation on it yet. I'm actually involved in a few at the moment, but I have nothing to go on. So when I get some of my chambering students or my young lawyers to do research, we have nothing in Malaysia. And we have to go outside of the country to advise our clients and bring back those case laws, which may or may not be on point, but that's all we have by way of an analogy. So you have to be prepared to look at new things that even your bosses or your partners may not have that much knowledge of. You have to, so this is something that you have to be prepared. You have to be prepared in incorporating technology in almost every aspect of your work. And this depends on your workplace, of course, the firm or company that you work in, but that has to be something you're mindful of. Can you work from your phone? You have to join case management from your phone. Can you do that? So I'm arming yourself with technology and equipping it in every aspect of your life, from work, for personal stuff, to work is something I think will give you an edge. It will make your life easier and your partners or bosses work easier as well. And I think the most basic principle and ground that you should have, and I think this last, or wherever it is that you want to go that is legal based, it is something that shouldn't change with times. Resilience in adversity. So as times change, you have to adapt and you have to be resilient. So it's being fluid and being stubborn at the same time. So being fluid, but being firm in your goal to be in this industry, be in the profession, doing litigation, and adapting to new norms at the same time. I think Chloe can go to the next slide. And I think that's it when it comes to some of the key points that I think that you have to look out for when it comes to the topic that I was presenting. Thank you all for listening. So I think I'll hand it over to Ranjan. I hope I'm still within time. And that's great. All right, thank you everybody. Thanks for listening. Back to you, Chloe.
Thank you so much, Ms. Idza. That was a really interesting presentation, especially about the AI in Labuan. Very interesting. I didn't know there was such a development. It will be interesting to see how that develops in the future.
Yes.
Now I will be sharing Mr. Ranjan's slide. Give me a moment. Mr. Chandran, when you're ready.
Good afternoon, dear participants. Thank you, Chloe, and thank you, Puan Idza, for the enlightening talk. As very correct and precisely put by Puan Idza, change is something which has been very drastic as far as the courts are concerned, as far as the future of litigation in this country is concerned. But as I said, change, as we know, is something which is constant in life, and change is something which is sure to happen. Change is something which all of us are compelled to follow because of the unprecedented COVID-19 pandemic. So that is something that which we will have to bear in mind. Now, I like what Puan Idza had expressed regarding what it was during the old days. We are not very far off. I know Puan Idza is 14 years, I'm 25 years, but I have spoken to much more senior lawyers, and incidentally, my father is also a very senior lawyer, 52 years in practice. What I noted is that in the older days, there's always an interaction between lawyers and the court. Yep. The interaction between lawyers and lawyers, interaction between lawyers and the court, be it the judges, be it the registrars, are always there. Yeah, and that is something which is going to be slightly diminishing. I will use the word cautiously slightly diminishing, because as what Puan Idza had pointed out, e-review systems, for example, are now all done by way of online system. A lawyer, a few associates in my office asked me this question, and they asked me, they said, look, don't you think the e-review system is good? And my answer to them was, with the greatest of respect, I disagree with the e-review system. And they asked me why. I said, this is my view. the beauty of a lawyer is to get ready to go to court, to get yourself attired for court, to wear your coat, to wear your blazer and to go to court, and to be able to engage with the judge, or to be able to engage with the registrar, and more importantly, to be able to engage with your opponent lawyers. That is something which you will find missing in the e-review system, because as you all know, written words can only speak so much. Nothing like interaction, direct interaction face to face. So that's why I say that even the old system of the case management, where we take the trouble and we go to court, we appear before the registrar, and we are able to articulate our words and also express our thoughts in a way that is filled with mannerism, with decorum. That is something which will be non-existent in the e-review system. So this is something that you will have to bear in mind. Yep. As students, young lawyers to be, you will have to bear that in mind, that there may be a possibility that the quality of advocacy may diminish. Yep. And we will argue about this, and perhaps upon Idza will also express some views about it on the quality of advocacy, because when you're talking about litigation in court, advocacy is paramount. Advocacy means a play of words. It means the way you present your arguments, how you're able to convince the court, how you're able to persuade the court. All these things, you can only do it when you are able to be present physically in court. Yeah, so bear that in mind. Now let's move on. Now that we know that we are forced to look at the future, albeit the views that I have expressed, this is something that we are compelled to do. So what our courts have done, as a further elaboration to what Puan Idza has explained, is that they had introduced what is known as an online hearing. If I may invite the moderator to this slide. On the 26th of March 2020 was the first time where the Federal Court Chief Registrar's office issued a statement stating that parties involved in civil proceedings can apply to court for hearings to be conducted online. That was after the COVID-19 pandemic was officially declared, yeah, by WHO, and also after the imposition of the movement control order. So it all started on the 26th of March 2020. Now let's move on to the next slide. Now, there have been a few cases that had a test run on this online hearing via Skype video. And as I said, although change is something which is constant and something which is sure to happen, there is bound to be challenges, there's bound to be resistance. Changes are not going to be adapted, are not going to be accepted for the sake of being introduced. There was plenty of challenges. One such challenge can be seen from this case of SS Prika Chandran Berhad and Serba Dynamic Group Berhad, and the citation is there. And here what happened was the validity of the Skype video conference, dear participants, was questioned. And the court held that it could proceed with video conference in light of the plaintiff's consent. That was the conclusion of what transpired here. The court said, no, we are proceeding because the plaintiff who had filed the claim, who had filed the application before the court, had agreed. Because what happened was the plaintiff's solicitors initially resisted to the Skype video conference, and they vehemently objected to the proceedings being heard via Skype. But the court noted a very important fact, that the plaintiff's solicitor, as you can see from the slide there, never informed the court, yep, of this objection, yep, and further, never formally, never placed on record the objection on the hearing via Skype video. Yeah, and the High Court judge had expressly asked the plaintiff solicitor whether the plaintiff consented to the video conference Skype, and an affirmative answer was given. So this resulted in the court having concluded that the Skype video conference could proceed, and the challenge was held to be without any basis. Yep, and there was also the active participation by the plaintiff's lawyer during the Skype video conference. So there you see, this is a classic example of a case where there was an objection to the online hearing, but the court sort of overruled that objection to say, you never said it in clear words that you had any reservations. Now moving on to the next slide. Then we have a case on a decision. The same case by Wong Keng Keong J, the same case of SS Precast, where Justice Wong Keng Keong, in justifying that the proceedings could go online and can be heard online, this is what the judge said, referring to Article 5.1 of the Federal Constitution and the decision of the Federal Court in Sivarasa, Rahsia and Badan Peguam, Malaysia. The learned High Court judge stated that Article 5.1 provides for a fundamental right of access to justice for the defendant in the present case. So what happened, participants, was this. The learned High Court judge said, look, you cannot be only looking at it from the point of view of the plaintiff. Firstly, the judge noted that the plaintiff did not place on record his categorical objection. But more importantly, the judge said, we have also got to look at the predicament of the defendants. Yeah, because they may also want a right of access of justice. They may not want their case to be delayed. They may want the court to hear their case expeditiously. If there's a way to hear it, why not? So that is how the learned High Court judge used Article 5 Federal Constitution. Then after that, the High Court judge also referred to Order 33 Rule 10 and Order 32 Rule 11.1, which gives the court the discretion to dispose of matters with such discretion as the judge thinks fit. And accordingly, the learned High Court judge ruled that the VC can be held in the interest of justice as it is consistent with a party's fundamental right. Yeah, that means the Skype video conference could be held. So two reasons that the judge backed up the contention that the video conferencing online hearing could go on. Yeah, the court has a discretion, and also Article 5.1. Now moving on to the next slide. Proposed Order 33A of the Rules of Court 2012. There, all the rules of court and the Courts of Judicature Act has been amended. Yeah, there's an Amendment Act 2020, which I will be enlightening all the participants. There's also a proposed Order 33 in the Rules of Court, because with the new online hearing and the new technology in proceeding with litigation, necessarily the rules of court, the Court of Appeal rules, the rules of the Federal Court, the Courts of Judicature Act, which is the Parent, Mother and Father Act governing all the courts, will necessarily have to be amended. So what does the proposed Order 33A Rules of Court say? It empowers the court or registrar to direct parties on its own motion to have proceedings conducted through remote communication technology. Yep, that's number one. Number two, allowing any witness or party in any hearing or proceedings to attend by means of remote communication, and the evidence to be given in person through a remote communication technology. Yep, so that covers the witness part of it. And examination in chief, cross-examination, re-examination, all done by means of remote communication. The last thing, yet another proposed change, allowing proceedings to be broadcasted to the public. So these are all the changes leading towards online hearing. Now we move on to the next slide. This is the decision which first started the the historical decision Zhao Fanglian and Syarikat Pengangkutan Satu Hati Sembilan Berhad, which the learned speaker upon Idza had enlightened all of you. And this was the first ever proceedings live streamed in Malaysia by virtual hearing, with parties being not physically present in court. And this was conducted via teleconferencing on the 23rd of April. And the panel of the Court of Appeal, learned Court of Appeal judges, they were sitting in their respective chambers or in their respective homes. Counsel for the parties who argued the matters were also sitting in their respective homes. As I said, I have strong reservations on the first ever proceedings live stream. As I mentioned earlier to all of you, nothing like appearing before the Court of Appeal judges in open court, nothing like counsel for both parties being present and both parties being able to display their skill and their persuasive advocacy before the bench and to be ready with questions. Yep, spontaneous questions which will be directed by any one of the 3 Court of Appeal judges in the Court of Appeal. For Federal Court in the leave application, 3 judges. In the substantive Federal Court hearing, 5 judges. So being spontaneous is something to my mind, which is, in my respectful view, is slightly on the downside when it comes to virtual hearings, because being spontaneous is something which is difficult, yeah, because it will take time to share documents, it will take time to draw the attention of the court to the documents that you would want them to see. So therefore, the spontaneous questions and answers and advocacy is somewhat diminished. But be that as it may, COVID-19 has brought about this change, and we will have to somewhat adapt to it, albeit our reservations and feelings. Moving on to the next slide. In Liz's Plantation and Liu Ayong, a very recent decision by Judicial Commissioner Su Tianju, and this is what the learned judge in his Judicial Commissioner in his grounds of judgment very aptly expressed his views and sentiments. The Malaysian courts have kept up with the march of technology. Case management of cases by way of e-review is widely used, and paperless hearings with the aid of technology in the federal court has commenced this year. You have the need for counsel, litigants, and witnesses to physically travel to court for hearing of the matters is getting less and less. Yep, and hearings by way of different platforms: Zoom, Skype, Google Duo, Google Hangouts, MS Teams, Adobe Connect. All these were the platforms, online platforms which the learned Judicial Commissioner took note of. Now, in this particular case, what happened was there was an application to transfer proceedings because the defendant was residing in Kelantan, in Kota Baru. So what happened was an application was filed in the Ipoh High Court for the plaintiff's claim to be transferred from Ipoh Court to Kota Baru Court. And this is where Justice Su Tianju said that there's no need to transfer the matter because we are now faced with the COVID-19 pandemic. In any event, it is difficult for parties to physically travel from court to court. No, and now with the technology and with all these Skype and online hearings, no necessity to transfer proceedings, and the court declined the application to transfer proceedings because of this march in technology which the learned Judicial Commissioner had expressed. Moving on to the next slide. Now, what are the salient matters, dear participants and young lawyers and lawyers to be? What are the things that you need to take note of for appellate online hearings? A few pointers from my experience, having appeared in a few appellate hearings and also in the federal court. Lawyers to give consent for online hearing, very important. Yeah, recently, just 2 days ago, I was forwarded an email by the Court of Appeal to ask whether I had agreement, any objections to an online hearing of appeal, which was scheduled for coming Monday. And I immediately wrote back and said, yes, I have objections and I'm not agreeable to that. And my client was also not agreeable to that. I got a letter and an email from the court saying that in view of the objection, we will not proceed with the online hearing. I had my reservations, as I said, for all those reasons that I've explained to you. So consent is important. Fill up the online or notify the court. Ensure all documents to be referred to at the hearing are scanned. Very important. Yep. Scanning of documents must all be in order for online hearings. If the documents are not scanned and if documents are, say, inadvertently left out, you will have a problem referring to it at the e-appellate hearings, either in the Court of Appeal or in the federal court. So please bear that in mind. Make sure all the documents are in PDF format. And again, to my mind, this is another headache which I faced in a few of the hearings which I had the pleasure of appearing in counsel. You see, the document pages in our hard copy differ from the document pages from in the PDF. Sometimes it could be page 5 in your hard copy. In the PDF, it could be page 7 or 8. So you got to be very careful and mindful. Do not assume that your hard copy documents are the same as the PDF format pages. And enclosure numbers are very, very important. Nothing moves in the e-appellate without enclosure numbers. Enclosure numbers must be informed to the learned Court of Appeal or Federal Court presiding judges, and only then will you be able to direct them to the relevant scanned documents for your online hearing. So obtain your enclosure numbers and PDF page numbers. Familiarize yourself with online hearings. Judges will only see documents that you are sharing. No physical references to hard copy of court documents. Okay, so bear that in mind. The judges will only see what you project. If you don't project it, then they will not be able to see it. Moving on to the next slide. Now, COVID-19 is, this is just for your knowledge, yep. On America introducing teleconferencing, hearing by telephone, Spain having its first internet trial, Britain changing its rules to require all evidence to be submitted digitally. All these are the changes which are happening not only in Malaysia, but all around the world in view of the COVID-19 pandemic. Next slide, please. Yeah, and these are some cases where, as I said, there are some cases which are appropriate for e-hearing, online hearing. There are some cases which are inappropriate. When it comes to child matters, yep, child evidence, as you can see, in this case, the remote hearing was held to be inappropriate in United Kingdom, yep, and because it concerned a testimony, yep, concerning a 7-year-old girl, and this girl had been harmed as a result of fabricated induced illness by the mother. And the court said that, no, we are not going on with this online hearing without the mother's physical presence in court. So pros and cons again. Moving on to the next slide. Another set of hearing in Australia, in Capic and Fort Moto, where remote hearing was held to be appropriate. Yeah. And the federal court considered 2 factors in particular, which was the need for practitioners and witnesses or court staff to work from home, and that public institutions such as the court must do all they can to facilitate the continuation of the economy and essential services. So here the Australian court took a different approach and said, well, remote hearing is practical, remote hearing is appropriate. Moving on to the next slide. The Courts of Judicature Amendment October, dear participants, yep, there has been amendment to accommodate and to permit televised live through video streaming As you all can see on the screen, Section 3 has been amended. Remote communication technology, has been an introduction into Section 3. Live video link, television, live television. Section 15A, court may, in the interest of justice, conduct proceedings in any of any cause or matter, civil or criminal, through remote communication. So the Courts of Judicature Amendment Act has been amended. Moving on to the next slide. I have a few more minutes. Section 17B, practice directions, allows for practice directions again to facilitate online hearings. Section 69, also again, or through a remote communication technology, is something which has been introduced in the Courts of Judicature Act. Can I move on to the next slide? Well, these are just some of the other articles which I've written on COVID-19 during the MCO and CMCO period. I think I'll end my presentation here and invite questions from all of you. Indeed, a pleasure to address all of you. Thank you. Moderator, can I pass the floor back to Ms. Chloe?
Right. Thank you so much, Mr. Ranjan. That was very interesting. So I actually have an inquiry. You refused consent to have an online hearing. So what's the status of that proceeding now? Has it been moved forward after CMCO? Or?
Sorry, if there's an online hearing?
Yeah, that you refuse consent to, and now run at a time where CMCO has been imposed. Can the courts perhaps compel you to do an online hearing anyway?
Well, the courts are accommodating at the moment. They're accommodating. So far, there's no compelling factor there because the courts are mindful that sometimes clients may also want to make their physical presence in the court. And of course, Puan Idza will definitely agree with me and echo my sentiments that clients always want to make sure that their lawyers are doing their job.
Absolutely, Ranjan.
Our greatest hindrance and our greatest enemy, our own clients. So sometimes they want to make sure that they can come and see us performing, and they want to see us addressing the court and to see that justice is done to their case because they are paying a lot of money. So to answer your question, Chloe, in view of my objection to the online hearing, what will happen is the court will patiently wait for the CMCO to be uplifted, and then parties will agree on common dates for the direct appearance before the 3 panel judges. Is there anything else you would like to express on that?
I mean, I've similar to you, I've also requested, has had to refuse based on instructions of clients as well on conducting of online hearings. I think for really for cases where it is quite complex, when the issues faced are quite complex and there's thousands and thousands of documents to be referred to, suitability of it being done online might be a question, not only for the lawyers but also for the clients as well. So to provide comfort level, I think, and the courts have been accommodating so far in that they don't force you if you're not agreeable. You see, but based on the cases that Ranjan has shared just now, that I see that there might be even a trend where you have to, but I don't know. Right now, they're not forcing me to go ahead with online hearings if we're not agreeable.
Do you ever see that becoming a development in the future, whereby courts will force you to do online hearings?
Well, as I always say, we lawyers are at the mercy of the court, and what I was taught by the senior lawyers, and in fact, my own father used to always say this: the court can do no wrong. Puan Idza?
I mean, we'll probably keep our thoughts to ourselves, but we will I think abide, because based on the decisions that you quoted, Ranjan, it seems that they are assuming, the courts are saying that they have the power to direct by way of Order 30, and if that be the case, I foresee that happening. Yeah.
Oh, that would be quite a development then.
But I think, of course, I think what is important is that we also must understand the constraints of the court, because during the tenure of our former Chief Justice, who introduced what is known as KPI, Tun Zaki Azmi, the former Chief Judge, the backlog was cleared. We had a tremendous backlog of many, many years. We cleared the backlog, but I think we may be heading once again to a backlog, because we must understand that safety is paramount, Chloe and dear participants. We must understand that the court is moving in slow mode, and rightly so, because our safety is paramount.
That is understandable, yes. Safety first. Well, we have about 2 more minutes left in this session, so I would like to open the floor to perhaps 2 questions. To any participants, you may turn on your webcam and ask the panelists any questions you would like to have addressed. Otherwise, you could also leave a question in the chat box and I can read it out for you. So while we wait for the participants to perhaps think of any questions, Mr. Ranjan and Ms. Idza, do you have, or if you could have one thing that you would want participants here to take away from this session, what would it be?
I think for myself, I would, my advice to the participants will be, whatever system that is being introduced, and we will take it that the system is for the betterment of all of us, and also to adapt with the changing norms and reality. What is always paramount is that young lawyers and students, and who are going to become members of this honorable profession, please always take note that you are expected to maintain the high standards of the bar. That is very important. Yep. Ethics and decorum is paramount. Yep. Take pride in your work. Whatever the system be, learn the system and take pride in your work. And make the task of the judges and the honorable judges of the panel, whether it is in the Sessions Court, whether it's in the Magistrates Court, in the High Court, Court of Appeal, Federal Court, wherever the system has been introduced, let them enjoy your appearance. Yep. Let them enjoy and let them remark that you have done justice and they have had the pleasure of having you appearing before them. That will be my parting advice to all of you. Puan Idza?
I think what you said was on point there, Ranjan. Insofar as my thoughts are, if there would be one takeaway, is what the only thing that's constant in our lives and in the profession as well is change. I mean, the profession has gone through a lot of changes throughout the years, I think. But litigation generally is here to stay so long as disputes are here. You know, it's a very interesting time to be in the legal profession and in litigation because of the changes. Disputes are changing, the nature of it is changing. It's exciting, it's scary at the same time, you know. Trying to beat the system, understanding the system and making your best out of these changes is something you will have to prepare yourself for, and you will have a lot of members of your brethren, which is all of us, to help you when you join us soon. Yeah, so that will be all from me.
Well, thank you very much for your thoughts, Ms. Idza and Mr. Ranjan. That, unfortunately, is all the time we have for today and for this session, I'm afraid. So thank you all for participating, and I hope that you participants managed to grab some ideas from today's session and will carry forth what Mr. Ranjan and Ms. Idza have told you about future of litigation. I'll also like to thank our panel now. Thank you for your time and for sharing. We're going to make use of your information.
Thank you, Leonard.